Hello, and welcome to today's episode of Legally Noirette or Legally Raven here. And today we're going to talk about change of venue. Studicata, is that how you say it? They don't say a whole bunch about it, so this is going to be a shorter video. And then we're going to do a follow-up video about seeking the home field advantage challenges to personal jurisdiction, where it is the civil procedure. And I'm actually going to read the chapter because I would like to be able to listen to it over and over again. And this way, I have an audio recording. How about that? All right, so let me go ahead and share my screen here, and we're going to talk a little bit about change of venue. So proper venue. If venue is proper, the court may nonetheless transfer the case for the convenience of the parties or witnesses to any court where the case could have been originally filed. For example, the transferee court must have valid subject matter jurisdiction plus personal jurisdiction over the defendant plus proper venue. Improper venue, if venue is improper, the court must dismiss the case or transfer the case to a venue in which the case could have been originally filed. For example, the transferee court must have valid subject matter jurisdiction, personal jurisdiction over the defendant, and proper venue. So once again, we see this twice. For it to be the proper venue, you have to have subject matter jurisdiction, personal jurisdiction, and then you have to have proper venue. Choice of law. If a court transfers a case to another venue, the law that the transferee court must apply depends on whether the original venue was proper and the type of the case involved. So choice of law. If a court transfers the case to another venue, so you're out of here, new venue, the law that the transferee court must apply depends on two things, whether the original venue was proper and the type of case involved. All right, so proper original venue. If the transferor court had proper venue, so where you came from, if the venue was proper there, then you have diversity cases. In a diversity case, the transferee court, where you're going, the court where you're going, must apply the law that would have been applied in the district court that transferred the case. So even though you're over here to the new court, in a diversity case, you have to apply the law of the old court. Federal question cases. In a federal question case, the transferee court, the court where you're going, must apply the federal law as interpreted by its own federal court of appeals. So let's read this again. Federal question cases. In a federal question case, the new court, the transferee court, must apply the federal law as interpreted by its own federal court of appeals. So here's the difference. In diversity cases, we see that they have to apply the law of the district court that transferred the case. In federal question cases, the transferee court must apply the federal law as interpreted by its own federal court of appeals. So in diversity cases, it's the law of the former court, the original court, the district court that of that area that transferred the case. In federal question, you have to apply the law of the federal court of appeals in that area, right? In a federal question case, the transferee court must apply the federal law as interpreted by its own federal court of appeals. All right, so there's the difference. Diversity cases, the law from the old district court. Federal question cases, the law by its own federal court of appeals. So sorry to repeat it so many times, but I just wanted to make sure that it's in my mind, and hopefully that helps it get into yours. All right. So now let's talk about improper original venue. So that we just talked about what happens if you have proper original venue. If you had improper original venue, if the transfer court had improper venue in diversity cases, in a diversity case, the transferee court, the court where you're going, must apply the choice of law rules of the state in which it is located, as opposed to the state law of the district court that transferred the case. So it's not the state law of the district court that transferred the case the way that it is if you had proper original venue. It's the choice of law rules of the state in which it's located. I don't know what that means. So let's look it up. The choice of law rules. Let's look at that. The choice of law rules. All right, let's go to Google. Google is our friend. And let's type in choice of law rules and see what it says. The choice of law rules in the state was a choice of law or governing law provision. Okay, that's in a contract. Oh, we're going to learn about this more. Okay. In the Erie Doctrine, in the Erie Doctrine. I've been hearing a lot about it, but I don't know what it is yet. So choice of law is a procedural stage in the litigation of a case involving a conflict of laws when it is necessary to reconcile the difference between, okay, Let's start again. Choice of law is a procedural stage in a litigation of a case involving the conflict of laws when it is necessary to reconcile the differences between the laws of different legal jurisdictions, such as sovereign states, federal states in the US, or provinces. The outcome of this process is potentially to require the courts of one jurisdiction to apply the law of a different jurisdiction in lawsuits arising from, say, family law, tort, or contract. The law which is applied is sometimes referred to as proper law. Oh, wow. All right. So that's what Wikipedia says, but anybody can change Wikipedia. So let's look here at, okay, let's look at Cornell, right? We kind of trust Cornell. So conflict of laws, a difference between the laws of two or more jurisdictions with some connection to a case, such that the outcome depends on which jurisdiction's laws will be used to resolve each issue in dispute. The conflicting legal rules may come from US federal court, the laws of US states, or the laws of other countries. So let's do choice of laws. We're gonna do and see where it is. Okay. Courts faced with a choice of law issue generally have two choices. A court can apply the law of the forum, which is lex fore, which is usually the result when the question of what law to apply is procedural, or the law can apply the law of the site of the transaction or occurrence that gave rise to the litigation in the first place, lex loci. This is usually the conflicting law selected when the matter is, how do you pronounce this? Substantive. I don't know, but I've been seeing it over and over again, and honestly, I haven't done it. So we're going to listen to how you pronounce it so that we can educate ourselves. So we know. Let's see. Merriam-Webster, do you have audio here? No. Oh, here we go.
Substantive.
Substantive. So I was wrong. Substantive. That's how you pronounce it. Substantive. All right. So let's go back here. Courts faced with the choice of law generally have two choices. The court can apply the law in the forum, which is usually the result of when the question of what law to apply is procedural, or the court can apply the law of the site of the transaction or occurrence that gave rise to the litigation in the first place. This is usually the controlling law selected when the matter is
substantive.
Substantive, having substance involving matters of major or practical importance to all concerned. So is it the law of the forum, or is it the law where whatever gave rise to the suit? Which one are you going to apply? Federal courts may play by different rules than state courts because federal jurisdiction is limited to what has been enumerated in the Constitution. The rules that federal courts must obey regarding which laws to apply are extremely complex. So, legally nor read, we just started on this journey. So here we go. So now we know with this choice of law here. So we're gonna go back here. So diversity cases. In a diversity case, the transferee court must apply the choice of law rules of the state in which it is located, as opposed to the state law of the district court that transferred the case. All right, so if the improper original venue here, the new court has to apply the choice of law rules of the state in which it is located. So we have to look up what those choice of law rules are depending on the state. We, of course, are studying law in the state of Vermont, so that's something we need to know. Federal question cases. In a federal question case, the transferee court must apply the federal law as interpreted by its own federal court of appeal. So improper original venue in a federal question case, you see the transferee court, the new court must apply the federal law as interpreted by its own federal court of appeals, right? So we see in both proper venue and proper original venue and improper original venue in a federal question case, in both cases, that new court, the transferee court, is going to apply the federal law as interpreted by its own federal court of appeals. Now, when we look at diversity cases, it is going to be different for proper venue and improper venue. As a review, if you had a proper original venue in a diversity case, the transferee court must apply the law that would have been applied in the district court that transferred the case, okay? They have to go with the former forum court, the transfer court, okay? And then in a diversity case of improper venue, they must apply the choice of law rules in the state in which it's located. So let's just do a quick Google search. We're learning how to research things, and we're gonna see what are the choice of law rules in Vermont. I don't know if we can find this, but we're going to try it. So let's go back to Google here. Now that we know how to pronounce, how do you pronounce it again? Substantive. All right, so let's go to Google here. Isn't that a cute cat? Love the cat. And we're going to look choice of law rules, Vermont. Okay. Oh, by state. So you can see all of them. Okay, it's choice of law rules. This is from the judiciary. Okay, so this particular is talking about choice of law provision and a computer information agreement that provides that a contract to be interpreted interpreted pursuant to the laws of the state that has. Okay, let's go back here where it said choice of law rules by state. And this is one thing. I love this, and I'm using the Right Law software, and they were talking about this too, about using quotation marks. So let's look at this. Choice of law rules by state. Oh, it took my quotation marks. Okay. So the Erie Doctrine Law Shelf. I'm not sure what Law Shelf is about, but maybe it's something. Watch videos and earn college credit, only $35 per course. Okay, don't know what this is about. Choice of law is a set of rules used to select which jurisdictions laws apply in a lawsuit. Choice of law questions most frequently arise in lawsuits in the federal courts that are based on diversity jurisdiction where the plaintiff and defendant are from different states. In these lawsuits, the courts are confronted with the question of which jurisdictions law should apply. The choice of law rules establish a method by which the courts can select the appropriate law. So you can't just say, hey, we're using choice of law. Once you say choice of law, now we have to know what are the rules that we have to follow to figure out which ones we can use, sometimes used interchangeably with choice of law. So that explains why we typed in choice of law. Google gave us conflict of laws because Google and God know everything, not in that order. All right. So a conflict of law arises when a lawsuit introduces conflict of laws of two or more jurisdictions. Okay. So like the Erie Doctrine, the choice of law rules, sometimes referred to as conflict of laws, focus on the selection of one jurisdiction's laws over another's jurisdiction in a particular lawsuit. As with the Erie Doctrine, the courts must determine which jurisdiction laws to apply in a particular case. All right, so let's look at this example here. George, a resident of California, is a store clerk in San Diego, California. Matt, an Arizona resident, falls asleep at the wheel and drives his car into George's store, damaging 90% of the store's inventory and landing George in the hospital for 2 weeks with severe injury. George sues Matt in California State Court for negligence and destruction of property. California law allows George to recover up to $60,000 for both of his claims. Arizona law, however, prevents George from recovering more than $45,000. George argues that California law should apply, while Matt argues that Arizona law should apply. What should the court rule? So this is a really good example here because we see, first of all, George is here minding his own business in his store. You know, something very similar happened. Ray Dalio, do you know him, the hedge fund billionaire? Ray Dalio's son, about a year ago, probably now, he ran his car into a T-Mobile store, was it? Or something like that. But I'm just trying to relate this to real life because it's like a lot of these things, Ray Dalio, son, car crash. If I'm not mistaken, it was a T-Mobile phone store, right? Smoke inhalation from thermal injuries led to his death. Billionaire rate crashing into a Verizon store. It wasn't a T-Mobile store, but it was a phone store. So this type of thing does actually happen. So we have George mind his own business, store clerk in San Diego. Matt falls asleep at the wheel. Poor Matt. Happy Matt's okay. Happy that George is okay. George, 90% of the store's inventory was damaged. George is in the hospital for 2 weeks of severe injury. George sues Matt to recover up to $60,000 for his claim. So you can only get $60,000. You can only get $60,000 you can get $60,000 in California, but you can only get $45,000 in Arizona. What would you choose if you were George? Okay, first of all, I already live in California. Okay, the store is in California. I can get more money in California. I'm certainly going to try to sue in California, but can I? The example described above is a typical example of choice of law scenario. Two parties argue that a state court should apply the law of their jurisdiction. There is no federal diversity jurisdiction because the amount of controversy is less than $75,000. So we learned that before. So $75,000 is that threshold, right? It has to be, it's less than 75,000. Nevertheless, there's a choice of law problem. George, the plaintiff, clearly would want to recover the largest monetary relief available under California law. On the other hand, Matt, the defendant, would want to limit his liability and implement Arizona law. The outcome of the lawsuit will be determined in a large part by which law the court applies. On which law should the state court base his decision? So where did he sue? Does it tell us? Okay, yes. So George sues Matt in a California state court for negligence and destruction of property. So here we go. We're in California, right? But what is it going to be? So one response would seem to make the most sense would be the state court to apply the law of its own jurisdiction. The California court will probably apply its own law with which it is most familiar. However, this is not always the rule. One reason that this is not always the correct choice is that it would, is this a typo? Anyway, would cause parties to forum shop. Forum shop refers to a situation where a party commences a lawsuit in a particular jurisdiction where the party will reap the greatest rewards. Forum shopping is discouraged in the judicial system and has a negative connotation. Therefore, if the state court always applied the law of its jurisdiction, plaintiffs would flock to a particular jurisdiction if it is known to allow the greatest monetary rewards for a particular legal controversy or because it has the fewest restrictions. The courts strongly disfavor forum shopping for this reason. The judicial system seeks to avoid clogging up certain courts with lawsuits while leaving others empty because their laws are less advantageous to plaintiffs. So the whole purpose of this is like, here you go. You can't just say like, oh, wow, things are great in California. I'm going to get more money there. I'm going to sue there because then what would happen? In this case, Arizona's case with courts would be empty and there would be a huge backlog in California. So what happens is, yeah, you can use the California court, but guess what? We may, if there's a conflict of laws, apply the Arizona law in the California court. So you know what? It's better to just keep your hiney at home in your home court. Okay. So another reason that the rule that a state court should apply the law of the state where the court sits has not been adopted is that the law may have little to do with the legal controversy. Okay, so for example, Pamela, a resident of North Dakota, sues Roger, also a resident of North Dakota, for a car accident that occurred in Fargo, North Dakota on September 1st, 2015. Pamela purchased a car in Bismarck, South Dakota. Pamela sues in South Dakota State Court for monetary damages. What law should the state court apply, North Dakota or South Dakota law? In this example, it would make little sense to apply the South Dakota law because it has little contact with either of the parties or the legal controversy. To resolve these issues, the courts have adopted choice of law rules to facilitate application of the proper state law in legal controversy. One significant problem with the choice of law rules, each jurisdiction maintains its own rules in this field. Therefore, it is essential to check the case law and local rules of the particular jurisdiction. Another problem that stems from the lack of uniformity in applying the choice of law rules among different jurisdictions is that it is impossible to cover all the possible permutations and variations of the rules. However, in an attempt to demonstrate the principles that are associated with applying these choice of law rules, the remainder of this section will highlight some of the basic choice of law rules that apply in many states. All right, so let's go down here and see. I'm really trying to, so this is kind of cool. So I like that example. Like I really understand it after that, but I'm really trying to find out what is the choice of law rule in Vermont. Let's do that choice of law rule of Vermont, and let's see what we get. Let's see. So this is the code of I thought it was here. Okay, Vermont statutes, Uniform Commercial Code, Article 4A, Fund Transfer, Choice of Law. The following rules apply unless the affected parties otherwise agree to subsection C applies. The rights and obligations between the sender of a payment order and the receiving bank are governed by the law of the jurisdiction in which the receiving bank is located. The rights and obligations between the beneficiary's bank and the beneficiary are governed by the law of the jurisdiction in which the beneficiary's bank is located. The issue of when payment is made pursuant to a funds transfer by the originator to the beneficiary is governed by the law of the jurisdiction in which the beneficiary's bank is located. If the parties described in each paragraph of subsection A have made an agreement selecting the law of a particular jurisdiction to govern rights and obligations between each other, the law of that jurisdiction governs those rights and obligations, whether or not the payment order or the funds transfer bears a reasonable relation to that jurisdiction, or C. All right, so this is saying or C applies. A funds transfer system rule may select the law of a particular jurisdiction to govern rights and obligations between participating banks with respect to payment orders transmitted or processed through the system, or the rights and obligations of some or all the parties to a funds transfer, any part of which is carried out by means of the system. A choice of law made persistent to a clause. Okay, so this is a lot, but what I'm understanding is choice of law seems to be different for different types of cases. That's what I think this means. I'm not sure. So that is something that I will research. Do you have to look at the choice of law for each and every type of case that you are doing here? So this is about the Uniform Commercial Code for funds transfer and the choice of law, okay? But what if we're dealing with a different thing? What if we're dealing with a divorce or a family law, or divorce is family law, or if we're dealing with a car accident like we saw before, or some type of other type of negligence, whatever it is, it depends. So anyway, the point of all of this is, if you've stayed with me this long, is we talked about change of venue, proper venue. The court may nonetheless transfer the case for the convenience of the parties or witnesses to any court where the case could have been originally filed. Okay, so the new court, the transferee court, must have valid subject matter jurisdiction, personal jurisdiction over the defendant, and proper venue. If venue is improper, the court must dismiss the case or transfer the case to a venue in which the case should have been originally filed, one where they have subject matter jurisdiction, personal jurisdiction of the defendant, and proper venue. Choice of law. If a court transfers a case to another venue, the law that the new court, the transferee court, must apply depends on whether the original venue was proper and the type of case involved. So in federal question cases, we see no matter whether it's proper or improper, the transferee court must apply the federal law as interpreted by its own federal court of appeals. In a diversity case, if it was proper venue, the transferee court must apply the law that would have been applied in the district court that transferred the case, okay? If it was improper venue, then the transferee court must apply the choice of law rules of the state in which it is located, as opposed to the state law of the district court that transferred the case. All right, so we had the example of what happened with that car accident in California, where one person was in California, one lived in Arizona. They had to decide which laws to apply. So you use the choice of law rules of the state in which the transferee court is located, as opposed to the state law of the district court that transferred the case. So we're going to look at the choice of law rules here, the new court, the transferee court. All right, so today we had a good time and we talked about change of venue. Thank you so much for tuning in to another episode of Legally Noirette.